Welcome to Third Fridays, the monthly legal talk show from Lois LLC featuring attorney Christian Seeson. This is the original forum in which real attorneys discuss workers' compensation issues, share their opinions, and engage in colorful conversations. This show showcases diverse perspectives of attorneys handling workers' comp cases, including case law trends, practical litigation strategies, and hot topics. Here's your host, Christian Seeson.
Hi, everybody. Welcome to the July 2025 edition of the Third Fridays podcast. We're in a different location today. Seems okay. I'm just kind of hoping that when our producer hears this, that he's not like rolling his eyes at me for changing the locale at the last minute. But, you know, the train doesn't stop moving for anybody. And so we're here today to talk about really an interesting development really by the Workers' Compensation Board. And, you know, it really goes to what this system is really about, right? The workers' compensation system is designed to compensate individuals for compensable claims and to deny benefits to people who do not have compensable claims. And it's very hard. That seems very basic, but the ins and outs of all of that really can result in something as incredible as this development. So to help me articulate this and what it means for stakeholders in our industry, I welcome back two of my partners here at Lois Law Firm, Addison O'Donnell and Meisha Powell. Welcome, guys.
Hey, good morning. How are you?
Thanks for having us. There's better air conditioning in here, Christian. Don't worry.
Okay. I was going to say, like, when you first nodded at the microphone, I wanted to let you know that, this is an audio podcast. So that our listeners weren't going to see you nodding at the microphone.
They feel it.
As a veteran of the show, and I think this puts you ahead now. You have the most guest appearances on the podcast. I thought you'd know that by now, but
it's like George Clooney on Steve Colbert.
That's good. That's a good comparison, right? I'll take either one. Okay, so the workers' compensation system is full of medical providers that render treatment to claimants in the great state of New York, and for the most part, everything is on the up and up. Everything works unless they come across our desks, right? I think our clients are not asking us to litigate cases where the medical treatment is going smoothly, where the medical treatment has a natural endpoint, that the claimant is returning to work, where this soft tissue injury is going to heal, right? We have a case of a doctor who applied for his authorization renewal, which I guess we can get into later. Isn't an authorization renewal even necessary anymore with the governor's sweeping changes of trying to just get every provider authorized? But interestingly enough, this letter was penned April of this year, and the board simply could have just denied the request, but there's actually so many pages in this letter that's not paginate that I'm not going to spend the time to actually count. This is a very, very long letter, and I think it bears a realistic understanding of what is happening behind the scenes here, right? You guys file appeals every day. How many pages does the board restrict you to?
8 pages.
Unfortunately.
8 pages.
Unfortunately.
They have gone well in excess of 8 pages to kind of explain to this doctor why his authorization is not being renewed. And this doctor's name is Vadim Lerman, with an address, several addresses, but Massapequa, New York, Bronx, New York, Syosset, New York, Brooklyn, New York, where he either has affiliations or practices directly. And I guess we can start out with the executive summary, where the board lists 5 reasons why Dr. Lerman should not be authorized to treat workers' compensation claimants. 1, he exposes claimants to risks of injury and complications from invasive procedures. He lacks adequate and or credible documentation, frequently failing to meet generally acceptable standards of medical record keeping, lacks medical justification or clinical indications for these procedures, calling into question the clinical judgment utilized in this medical decision-making, and demonstrates the submission of prior authorization requests to perform procedures outside of those generally provided for within the medical treatment guidelines without the requisite supporting medical justification, and exhibits billing irregularities in his practices for such procedures. Now, what are your first thoughts when you read that list of 5 things? Is that like, wow, this is bombastic, this is tabloid central? Or do you guys feel that this happens across the board?
I was thinking that. I'm like, are they all guilty of this? But okay, yeah.
I think that especially as litigators, right? Like we deal with these expert witnesses, these doctors, these medical providers almost on a daily basis, if not on a daily basis, because those are the doctors that are actually ruining the system, right? They expose the claimant to more treatment. They tell the claimant that body parts are involved when the claimant never even complained of them. They're adding diagnostic codes to their bill so that they can just get paid. And, we think about this like exposing the claimants to risks of injury and complications from invasive procedures. A lot of these procedures are like that. A lot of these procedures that we deal with, these fusions, that result in, potential spinal cord stimulator, right? All the instruments that are needed to kind of open the claimant up, stick it in there, and then, the hardware removal. And this becomes this process that actually prevents the claimant from returning to work. So when you see this like list of 5, I guess, examples of his conduct, did you guys get the sense that more doctors are going to be called to the carpet like this? Or did you get the sense that, maybe this particular doctor is so out of bounds that the board had to make an example? Or is there another option that you guys thought?
I mean, this reads like an indictment. These are 5 charges. Remember, when a lawyer, pens a nastygram, it's a legal term of art, right? Making allegations. These allegations, they can't just be frivolous. They must have some substantial evidentiary proof behind what is being alleged. And so with these 5 charges, and of course, this correspondence was signed by, a deputy counsel of the board and the medical director of the board, who was a lawyer and a doctor. His parents must be so proud.
My parents are.
I can't help but imagine what was going through these counselors' minds in penning this multi-paged indictment, right? This 19-page indictment. The executive summary truly evinces what's day in, day out here at Lowe's Law Firm. Right? We have surgical procedures that we consistently object to, consistently litigate over. We regularly defend our clients' interests by citing the lack of documentation, and if there is documentation, how incredible it is. We use the PAR system and the medical treatment guidelines to, quite honestly, continue the treatment on a normal path. Right? If someone has a soft tissue injury, there's no credible, reasonable rationale to have a fusion, to have a removal. And we joke about C1Bs, right? We joke about billing irregularities, but that's really the groundwork for this doctor's allegedly illicit conduct.
And I think too, right? Talking about how we see this all the time, right? In the first case that they detail, they say that the doctor does not include the spinal levels where cervical epidural steroid injections were performed, did not include the date of the injections, did not document whether the claimant had any relief from the prior injection. And then based on this information, the doctor recommends an invasive surgical procedure, specifically an ACDF, right, an anterior cervical discectomy and fusion at C5-6. I mean, those words, I say them so quickly mostly because we say them all the time, right? An ACDF, that's just always going to be in my mind because we see them so frequently. And you guys see this all the time in this PAR system where the provider does not meet the prerequisites, even recommend the procedure. Do you believe that the PAR system at that at least initial stage successfully denies a procedure like that? Or do you feel that the PAR system results in the granting of too many of those types of procedures?
I mean, unfortunately, I think it does sometimes result in the granting of those procedures. And I always find it so interesting. I mean, you're talking about like a major surgery. And to me, if it's not like very specific, very detailed, if all the boxes aren't checked, I don't even know how some of these procedures are being granted. I think it's unfortunate that I think, like you said, we're saying it like, oh, it's like an everyday thing, but it's really not, right? It's really not. It's very serious. It's very, complicated, complex, but yet you do have, I think some of them kind of slip through the cracks.
Yeah.
Right. And they're granted. And then once they're granted, the carrier, like, we're left to nothing.
Right.
Right. We can't even try to like go back and say, well, no. We think that this was granted in error. You missed this one thing. We
two
can't.
cases out of the two.
Done. Yeah. Exactly.
Right.
We
Better
can't do
brush your
anything
teeth.
about it. Yep.
The interesting thing is like to actually submit the request, right? And to get a valid request, it then now goes to this really, really harsh deadline system where the carrier then has to think about, for instance, in this situation where if the provider does not provide all of the materials that are necessary to determine whether the procedure is correct, medically necessary, causally related, the carrier is then left under this same deadline to go back into the file, review all those records, and determine whether it was documented somewhere else, right? And you'll see that sometimes where the denial paperwork for a procedure will reference medical reports in the file that weren't even submitted by the doctor. So what's interesting thing is that it's like, it's almost like sometimes these doctors know that they should be submitting more of what they are. And the board here is calling this case to the carpet and saying that, well, you didn't even tell us that you kind of had the table stakes, like the cover charge to get into the bar so that you can actually have a drink or order a meal. You're just skipping through, blowing past the line, and then just presenting a bill to the carrier, and actually goes through some of the process here in the case where this I definitely see all the time, where a PAR is rightfully denied. At level 2, what does the provider do?
Prove it.
No, the provider restarts
Resubmits it. Right.
at level 1.
Yep.
Instead of going to the medical director's office at level 3. And that's what they call out here. They say it was denied, and had this been escalated to the MDO, it would have been denied for these reasons. Didn't clearly identify the etiology, claimant still undergoing conservative care, with the ESI documented to have provided temporary relief. And of particular concern is that you determined a surgical procedure was required at the first initial consult. Oof. Can you imagine going into the doctor for anything and they say you need to have surgery? I was like, how do you know?
And I would put my money that this doctor didn't review any prior records, didn't even see whether there was an MRI conducted, didn't even want to try conservative treatment. This is the thing that I tell this to the newer associates. I try to explain this in concrete terms. Imagine going to a doctor. Imagine this doctor saying that, saying you need your neck fused. An ACDF, we say it like it's alphabet soup here, but that's a fusion. That means there are bones, there are spinal columns that get fused together because of what occurred. And, this is an extreme example, but, a low energy mechanism of injury, which may result in less than a bruise, can't possibly result in a causally related fusion. It's incongruous. It's preposterous. It's immoral.
Yeah, it's pretty bad. It's pretty bad. It's not good. And I think that, if I think about the PAR process in general, you could make an argument that it's actually helpful to practitioners. But this is one of those risks that come in where it's just like, an ACD, like requiring a doctor to actually fill out a paper form, right? Those old variance requests, right? Those C4 auths, and like having to write down exactly what, constitutes a complete form. You had less risk there, and you had more time for, and again, like I'm not that sorry that an employer would want to really determine whether one of their employees needs this life-altering surgery. But yet this person is going to keep continuing to resubmit it in hopes that someone's asleep at the wheel,
Right.
hits the wrong button, misses a deadline because maybe they were out of the office on one day, and all of a sudden the procedure gets approved, and now the case is exponentially worth more to the claimant, right? But in the long run, that's it. I mean, the claimant is maybe never going to go back to doing the pre-accident job at the level that he or she was doing it prior to. Because these workers' compensation surgeries somehow magically never result in lower loss of wage earning capacities.
Right.
So that was one case. Second case they talk about with Dr. Lerman is that he again recommends an ACDF at C5-6, again does it at the initial consult, requesting the procedure without a full evaluation of conservative treatments, right? I think that's basic at any medical level. You go to a doctor for anything, you should be trying stuff that doesn't require surgery, right? But just immediately determining that a surgical procedure is necessary. And in this bullet point, they say, this is concerning as it evidences an element of predetermined treatment focused on select surgical procedures to the exclusion of other diagnoses and treatments. I mean, it's almost as if, there's a system where you go to Dr. Lerman for the ACDF at C5, C6. You got conservative care? He could put it, he could make a request. The insurance company can approve or deny it. If they approve it, your case is worth X amount of dollars. It's actually pretty crazy that in this same case, he then also submits a PAR for posterior lumbar fusion and decompression at L5-S1. Like, is one body part not enough to potentially damage someone's future prospects? We're going to go for a second one. Same doctor. No, the conservative treatment attempts were still in progress with no evaluation of whether the therapy was producing a positive effect. And that's the thing that sometimes comes out on depositions, right? You guys do these depositions, you read these transcripts, you write your briefs, and I see this all the time where the IME doctor is never credited with reviewing the entire medical history of the claimant's case, right? We get that into the record. Claimant's doctors readily admit they don't review any prior records. Addison, you brought this up earlier. That is never a reason that a law judge or a board panel cites to as why the IME doctor is more credible. Never. I have never seen that in all the years that I've been doing this. To have a complete medical history versus your opponent having none. Surgery is authorized. Claimant's doctor is more credible.
Can you believe, I can't even imagine going to a doctor after treating somewhere else and then that doctor suggesting the most invasive form of treatment without reviewing those records. I can't, if a friend of mine, if a loved one told me about that, that would I'd say this doctor's nuts. Just to bring it back to a 10,000-foot view, we're on page 5 of this letter, this correspondence, and it reads like an indictment. Look at, I'm just bullet point after bullet point.
It actually is very accusatory. It's always, you did this, you did that, you did that, and it's just, it's 19 pages of this.
I mean,
we wouldn't have done this, we would have done this, you did this, you didn't do this. I mean, same case again. Submitted a PAR for a lumbar fusion procedure of L5S1, denied by the payer at level 2, not escalated for MDO review. This is considered a major surgery that should not be requested or undertaken lightly, and if you believe that the procedure was medically necessary, it begs the question why you did not escalate the PAR for MDO review. I mean, that's a pattern, right? At level 2, we just start at level 1 again. It's like your kid playing a video game and you can't get past a certain level. So once you're about to lose, you just like turn it off and start at your last saved place.
Is that a universal experience?
Well, for a child like me, sometimes you just need it to reset.
That's right.
You take the cartridge out of the thing and give it a little shake. I guess the point I'm trying to make is that when these things are happening, does this have value for the two of you as litigators in other cases, right? Like, is there something within this, whether it's actual context, actual content, or really the ideas surrounding it, that can be used in cases today?
I can see why they flagged this doctor, in that if he's going through the PAR system, and as you said, as he gets to level 2, he just starts over again. And I think, Christian, you are right. I think what he's hoping is that, let me just resubmit this request and hope that, someone's asleep at the wheel or they miss a deadline, and then it gets authorized and then he gets to do the surgery. I mean, when you think about, again, I'm going to say this again, the seriousness of what he's asking here. This is like major surgery. It's not an everyday thing. And for him to do that, like, it's almost like, oh, you know what? Let's just resubmit it again and hope that it gets approved. I mean, I can totally see why this letter was penned and why it is reading like an indictment, because what are you doing here? Like, this is really egregious when you read through it. It's really, it's troubling.
I did. Let's see. We had like 22, 26 for the first Meisha. What are we even doing here?
What are we even doing here?
Yes.
One of Meisha's signature questions.
Yeah. Oh, what are we doing here?
It took us this long to get to that.
We got it here. We're
the
here.
Idea, right? Then I'll throw it over to you, Addison. Right? The idea that of whether it can be used, if you were, let's say you were a law judge, let's say you were a commissioner on the board panel, and a practitioner cited this correspondence to compare it to a medical provider in their case that was doing something very similar. What do you think the board would do in response to that? What do you think the law judges that you guys interact with in cases, how would they take it?
What looks at first to be remarkable or bizarre reveals itself to be part of a greater pattern.
That should be on like a postcard or something, or like a greeting card.
And so it strikes at the heart of this problem. We look at cases in workers' compensation, case by case, line item by line item. We don't look at cases in the aggregate as much. And, Meisha from the construction standpoint, I from the appellate standpoint, sort of see cases in a different color, because we're seeing a conveyor belt. We're seeing these patterns emerge. We see this dance between means and ends, where doctors will achieve the end of surgery no matter what the means are. And it's our job to say, wait a minute, actually the means are just as important as the ends. If this letter were cited as a comparative tool to say that much like the board's recognition of Dr. Lerman, conducting himself in this uncouth manner, so too is this doctor in this specific case. I would say that is an extremely creative argument, and it's very compelling because it in order to get out of it, you would have to ignore the obvious, ignore the patterns.
I was wondering if you were going to actually answer the question I posed, because you start off with this nice little soliloquy that I was like, oh, is he trying to sidestep the question? Because I'm going to keep asking.
No, it's about patterns.
But
I think I see what you're asking. So, and Addison, I think you touched on it a bit here, right? So if you go in and you say to the judge, hey, this doctor, let's call him Dr. Marola.
All right, here we go.
Right. This Dr. Marola seems to be engaging in the same practice that this doctor, Lerner, is also doing. Lerman, right? In that, he's requesting the surgery, without, proper documentation. And then once it's denied here, he's, resubmitting it. The judges are interesting creatures, right? So you can submit that and they might say, well, this is a different case.
Sure.
These are different facts. I don't think it's relevant to this case. But again, as litigators, as defense attorneys for the carrier, I think we should continue to say it. We should continue to make the comparisons. I think when we look at these cases, we do look at them like in a vacuum. And we don't look at them like across the board. Like, well, judge, in 5 other cases, this is what's happened. I mean, we're going to be met with the same resistance. The judge is going to say, well, in this case, these are the facts, and it's not relevant what happened in other cases.
I think that's very interesting, too, because it's almost as if we find one judge who will at least hear the argument, that's reason enough to make the argument.
Correct.
Right?
Yeah.
We're not going to be thrown out of court in every single courtroom across the entire state. And some of these they're not just your garden variety, this provider had the same exact findings, requested a procedure, was denied. So you should deny this one, judge. Like that's not, we're talking about a case where, I'm reading from another page where a medical report contained in the board's case file indicates that the procedure was performed on said date by Jeffrey Thompson, one of your practice partners. This again suggests an affiliation in which you have submitted a PAR for a surgical procedure on behalf of other providers in your practice, and they performed such procedure despite the lack of approval or resubmission by them, the surgeon who performed the procedure. Imagine that.
Oh. Yeah, that's, as you were reading that, I was like, oh my goodness, that just sounds horrible. Like, so basically they submitted the request, it was approved, but it was done by a different surgeon.
Yeah.
And then that different surgeon bill. Yeah, that's the suggestion is that you're getting another surgeon to bill under the fee schedule for those services. It's double dipping. I mean, that's the surgeon who wasn't even affiliated with the request in the first instance. I mean
the board does a nice little solid for employers in the next sentence. They say that the insurance carrier objected to payment for this procedure, and a decision was issued in favor of them because the treatment deviated from the guidelines and no variance was obtained. So it's like the procedure was done and then was switched over to a different provider, and now you have, I guess, almost like a runway for the carrier to deny a bill because actually, it was approved for this doctor to do it. Right. I don't know about your partner.
And look at this. Moreover, the procedure was performed at a different level of the lumbar spine. Not only a different doctor, a different vertebrae, a different level. Whoops. I mean, it's egregious. It's egregious.
You see those because you see those like TV shows where someone's going in for a knee surgery. So like the operating nurse labels not this leg for the doctor, right? But in case you can't actually do that with the levels in your spine without opening the person up. It's pretty crazy because if we talk about citing this, right? You're not citing, oh, this procedure was denied in this case, same facts, deny it here. You're saying this is a pattern across the entire industry where they're doing this, right? And if I stop there, I could even see judges saying to me, oh, like it's a different case, right? Because there are a lot of judges that don't really think that this is a problem, right? They see the system as, the claimant needs treatment, the claimant needs money. But you can now use the fact that the board, the workers' compensation board, is telling this provider, not only is this not correct, we're not going to allow you to ever treat a workers' compensation claimant because of how egregious your behavior has been. That's really inflammatory.
I mean, he still has a medical license.
Well, I don't think that the workers' compensation board can do that.
No, right,
Not
but
yet.
he's a blight on the world. I mean, take a look at the next case here. This one actually gives me a pain in the heart. This claimant's 24 years old, and he's refusing to go. Look, he's refusing to go for additional ESI, right? The steroidal injection treatment. And this claimant's saying, stop. I don't want this anymore. I don't want this anymore. And what happens? Fusion. I mean, 24 years old, low energy, very tame and subtle mechanism of injury, and a 24-year-old. I mean, that's this kid. He's a kid. His life is just ahead of him, and really, this indictment is getting darker. It's now painting Lerman as villainous.
I almost want to believe that Dr. Lerman didn't actually meet this 24-year-old individual. That they just have a system. If you're recommending an ACDF on first blush, right? You see a 24-year-old walk into your office. Any sane person is going to be like, wait, you know what? I know we have this unethical thing that we do where we recommend ACDFs. This person's 24 years old and he actually doesn't want the conservative treatment. What mode in your head then says, let me open up his neck, open up his back?
And the MRI did not indicate nerve root compression. And for our lay audience members out there, MRIs can sometimes show nerve root impingement compression, which essentially means that the bone is, touching or butting or piercing the nerve root, which may be correlated with radicular symptomatology, right? Pain shooting down the leg from the spine. MRI shows none of that. Doesn't show instability, right? Doesn't show anything that warrants emergency surgery. Posterior fusion. I mean, the kid's 24. And if I were penning this, I would actually put this first. I wouldn't have waited until page 11, because most people don't wait until page 11, right? I'd be surprised if Lerman, continued reading until page 11. I would want the most extreme thing up front, the most amoral,
The writing expert is going to say,
Scenario.
put your strongest argument up front.
scenario. I know, and and I'm choking up because I imagine, I imagine a loved one going through this and begging not to go undergo ESIs anymore, begging for the conveyor belt to stop. I mean, it's a misuse of the medical profession.
Well, that too, it's not just that. I think, even people that get bad advice from any type of professional, they have the right to deny it, but a lot of that comes from the support system that they have, right? Their family, their friends. And when that gets overtaken by attorneys who have financial incentives, by litigation funding firms who say, you need to do this, to do that, to get this, to get that, or we'll fund your inability to work. Here's X amount of dollars to keep you sane, but it's really an implied quid pro quo where you have to do something in return. I mean, you're talking about they're going down there and they're listing all the risks that that Dr. Lerman is actually listing death, bleeding, infection, dural tear, dural leak, nerve damage, paralysis, hoarseness, vocal cord paralysis, dysphagia, esophageal injury, the need for repeat surgery, failure to heal, to fuse, and failure of hardware. Like, I'm sorry. Like, if I go in there and I see death,
Right.
like, I have to actually be facing death for not having the procedure to go forward with it. And so it's almost like, you feel like this is like a copy and paste job, right? Like, let me take the medical literature and copy and paste like the risks and benefits of the procedure. Who knows whether you're actually explaining it to the person just because it's on a piece of paper, or here, sign here, right?
Well, remember now, we're in this world of, the RICO cases that have been filed. And, you have to remember these claimants are, Spanish speaking, they're poor, they're, so a lot of it is, hey, if you do this procedure, I know you don't want to do it, but if you were to do this procedure, you could come out of this a millionaire at the other end.
Yeah.
Right? So just think about that. It's not just like, the attorneys that will benefit, the doctors that are being paid. The claimant himself is being told, this 24-year-old, like, hey, I know this is not what you want to do, but if you were to do this, your case can go from a $30,000 case to a $5 million case just by the mere fact of you going through this procedure.
It's like, you just have to hope that the comp claim is not defended by Lois.
Right. Because we will fight this. Yes.
And you have to hope that you don't die.
Right.
I mean, that's the most interesting part of this. And you're right, Christian. This is copy and paste because look, you noted this correspondence alleges a long discussion, quote, with the claimant about the risks and benefits of surgery of the cervical sick spine. Sick, SIC, for our lay listeners, is spelling incorrect. That means that the preceding word term is an incorrect one. We're talking about a lumbar, which is a low back fusion, and he's saying, oh yeah, I had a long discussion with the claimant about the risks and benefits of this neck fusion. It suggests copy and paste, right? That's the beginning, middle, and end of that one. We have to move on.
Well, what really brought your attention to this, Addison, is actually a footnote on page 2, which, as we go through it, I have to correct myself. I did say in the beginning that it's not even paginated. It is on the top left-hand corner. I don't know who does that.
Yeah. The board.
Who paginates on the top left-hand corner of a document? Right?
It's where the staple goes.
Top right, bottom right. Those are the only options.
Center bottom?
So center bottom. Center bottom, okay.
Sorry, hashtag appellate attorney.
Okay, fine, center bottom. Center bottom with like a dash, number dash.
No. Classic is always in style, just the number.
So let's talk about this footnote because it really goes into maybe why this letter was penned in the first place. And this is why you came to me and said, this is a great talking point here.
I believe I called you. I believe you were busy on your calendar, and I said, I have an emergency phone call for Christian Cison. Remember in the beginning of our conversation, I said that this was a correspondence directed to Dr. Lerman, penned by the Workers' Compensation Board. Sounds like an indictment. 2 lawyers signed it. I, as the eagle-eyed appellate attorney, I look at the footnote, and I will read it word for word. The majority of these cases were brought to the board's attention by a system stakeholder in the context of Roosevelt Road Reinsurance Limited et al. Versus Surgicare of Westside et al. And then citing the docket, the case docket number and its progeny, collectively RICO matters. The instant determination details out the treatment improprieties. That's very legal of them. In the below, set forth 5 workers' compensation claims, and for the sake of brevity, and brevity's in quotes, they're sort of making fun of themselves that this is a 19-page correspondence, does not set forth substantially similar findings related to your treatment in other cases.
How do you feel about the comma outside the quotes, brevity?
Well, so in the United Kingdom, that's proper. In the United States, it's not. I will give it to the doctor, lawyer, medical director who signed it. That's fine. I wouldn't do it. I wouldn't recommend anyone else to do it. But
so the doctor was named in one of the litany of RICO filings, RICO cases, and the board saying, let's look into this.
I mean, that to me jumped off the page. The state of New York looked at these allegations from the reinsurance case from Roosevelt Road. That's the tradesman matter. The Roosevelt Road case. And the board said, well, let's assume that these allegations are true. What will come of it? And then corroborated using the PAR system these allegations. They couldn't have written this correspondence without going to the PAR system to corroborate the allegations made in the Roosevelt Road case, because Roosevelt Road didn't undergo deep discovery. They wouldn't know. They're just making allegations. You know, correlation sometimes is causation. And when I saw this footnote, the first thing I said was they didn't have to write this footnote here. But this footnote sent a signal not just to Dr. Lerman, but to all stakeholders who had, who got their paws, so to speak, on this correspondence and said, hey, the board is reading this. The board is conducting, it must be conducting its own investigation on this.
It had to. I mean, they're saying that they did it at least for Dr. Lerman, which also begs the question. I mean, Dr. Lerman is not by far the only doctor named in any of these pleadings. And so to get to this point, I think what excited me the most is people are going to know what we know.
Yes.
We know this has been happening, and yet we are being called the bad guys, the people who prevent claimants from getting benefits. It's just, hold on a second. These are the true bad actors in this system, right? They're extending these claims, really putting claimants out of work, taking away their ability to contribute to the economy, contribute to society, and doing it in a place or in an area where physically and mentally and emotionally, they may never get to the point that they were before. And so these allegations that come out in civil court, if it leads to something like this, I mean, I'm not often, championing, pounding my desk for the, I don't want to use the word aptitude, but the fervor of the board in trying to do something like this. This is, this is incredible. This is incredible because this was not required.
Right. And, this does reveal something about the nature of the plaintiff's bar. The plaintiff's bar often says, we're for the people, and, the carriers are evil and whatnot. And, the rhetoric is really, really horrible. As someone who was basically plastered on a plaintiff's bar event, my face was plastered up on this PowerPoint as a public enemy number one. I am particularly sensitive about this, but, the truth is that our side is for the truth. We're for the truth of whether what is being alleged actually is true. And the board happens to be writing this, and the board's aim is not necessarily to help the people, but to get to the truth. And I think, once again, sometimes correlation is causation. I think now that we're aligned, because we've always said, hey, what's the truth of this case? And now the board is saying, well, what's the truth of this case?
Well, speaking of the truth, right? Sometimes maybe the truth needs to be disclosed or exposed, right? And, the claimant's bar is really jumping for joy at this development in the Roosevelt Road case, right? So we're here to pour some cold water on that and still uphold the integrity of employment in the process and really what's going on. So can you guys talk about what has been a recent development in that case and what you think it means going forward?
Well, the first thing is that the plaintiff's bar truly doesn't understand how to play with the big boys, because they think that they won. They read this and they go from beginning to end and say, that's it, it's over. And it's not. Quite frankly, it's just begun. Yeah, it's only when what we have here is a memorandum in order from the Eastern District of New York. We have, a motion to dismiss resolution where Roosevelt Road, as a reinsurance company, and others alleged racketeering, right? RICO, based on a group of stakeholders in and around the workers' compensation system. One thing that's important before we dive into this is that racketeering, conspiracy, you don't need to actually know that you're part of a conspiracy or a racket to be implicated in that racket. It's one of the inchoate crimes. It's one of these things where, I didn't know that the Italian restaurant was, funneling money through the olive oil factory, through, you think of those old Italian mob movies, right? Well, I didn't know. You didn't need to know. So long as you didn't question where the money came from or where the money was going, that's the racket, right? So in this case, the Judge Gonzalez, and it's actually not too bad of an opinion, because he's teeing up the plaintiffs to say, try again, without prejudice, try again, refile, and plead a cognizable direct injury.
Right. It's just the amended complaint filed by the plaintiffs in this case was thrown out by Judge Gonzalez, and you see it on LinkedIn, you see it, at your cocktail parties, like, oh, it's over, we won. And it's like, wait a minute, we deal with these two words all the time.
Without prejudice.
I hear those words or say those words every single day.
The AWW is said
without prejudice.
Right? Like every single day. C8.1b is without prejudice to the body parts being established. And the judge gave them basically almost akin to a labor market attachment decision. No, claimant, you have not attached to the labor market because you didn't do A, B, C, D, and E. And so what that really does is tell the claimant how to attach to the labor market. And so this idea here that the complaint is gone, that the RICO claims are out, and everybody's jumping for joy, it's like, I think you guys should put the good champagne away, all right? Don't drink it just yet, maybe if ever, because now there's an understanding of what should be in the complaint for refiling. Right? So nothing from the perspective of employers, insurance carriers, any of the people who justifiably combat fraud every day, nothing has really changed from this order.
I totally agree. And Meisha, you could probably explain some in a construction context what certain patterns are. Part of this scheme had to do with runners. And sometimes, in construction, that's a hush-hush thing, right? Where people are staging fake accidents and whatnot, where people are taking pictures of someone sprawled out on the floor,
Or of a hard hat.
That's right.
Yeah, in construction, I think these patterns are seen pretty often. And I think, like you said, they have so many different players, right, that are creating this world where, you have people on construction sites. Some of them are not even on the construction site, but they're claiming an accident, a serious accident too, falling from scaffolds, tripping and falling, because they want to be able to file these claims because they know at the end of the road there's $1 million plus payout. So you do have these individuals, these runners that are at the sites. They're at OSHA training courses, right? And they're actually soliciting these individuals. And what are they doing, right? They're saying, hey, we'll pay you, I don't know, up front, $20,000 to file this claim. Just fill out this paperwork, sign here. And then they're putting them in with, specific attorneys to kind of force these cases through. Now, fortunately, here at Lois, we have been, I would say, pretty successful in getting a lot of these cases disallowed at the trial level, because I think when I, actually defend some of these cases, the most interesting thing to me is that they send the claimant in there, right, who has no idea how this construction site is even set up. right? And you're cross-examining this person and they can't even tell you how they got into the construction site. Meanwhile, you have these big contractors, these big construction sites. They're set up in such a way where, you have to go through security, you have to use a scanning system, you have to have an ID, a badge. The hard hat, which was, I think, one of the biggest things that was ever discovered while like litigating these cases, where these guys are wearing these hard hats and they don't realize the hard hat has like a number on there that identifies who they are. No idea. I didn't even know, right? How did I find out? I'm talking to the employer and they're like, oh yeah, every guy has a number, right? That number's stamped on their hard hat. And, they go and see them on the construction site. They know who they are just by the number. So because it's such a complex system, right? You might think these guys are just on a construction site, but it's actually set up very specifically, right? There's a very nuanced way of how they, have their contractors in, the subcontractors, the GC, like there's so many layers. So then you have the claimant who has no clue, no idea. And they're sending these guys in there like, yeah, just say that you had an accident.
Wear this hard hat.
Yeah, wear this hard
Which
hat.
is not a number that is associated to you, but maybe to some other claimant.
Correct, and that's actually happened. Think
But
about
they
the
say
fraud
that
shit.
we always say that the biggest identifier of a workers' compensation claimant is whether they filed a claim before, or they know someone who's filed a claim before, right? And so that these
Correct.
stories kind of persist in a way where it really only takes one fraudulent or fabricated claim to get by.
Correct.
And now
Yes.
that person thinks that they have the sauce, right?
Mhm.
The secret, the elixir. And this idea really has only started happening at the forefront because it didn't used to be this way. It used to be like, okay, like it was just easier to get a claim being made compensable. But now, just like everything else in the world, it is harder to prove something that didn't actually happen.
Oh, yes.
Right? There's just layers on layers of different like truths that are out there to be dispelled, to be proven, and I can't be too excited because you think about the claims that you're disallowing, Meisha, right? Some of those claimants, they already went to Dr. Lerman. They already went to Dr. Marola. They already went to the doctors that Subin told them to go to. They may have already had procedures that they didn't need, and then they get their claim disallowed.
Yes.
Then what?
That
Then
happens.
what?
That
Now
happens all the time.
like the fact that you're using the workers' compensation vehicle to increase the value of your general liability claim in civil court, that's all gone. Like, who then
Well,
is holding the bag?
That's an interesting point because just because the workers' compensation case gets disallowed, that doesn't mean that the civil action is also ended. That continues.
It just makes it hard.
It just makes it harder for them. But again, I mean, I've had cases, the guy's found fraud, disallowed, but he's still treating,
right.
still going under surgery. Because at the end of the day, on the civil side, they're going to look at all of this and say, like, maybe it was just a farce. Something weird happened in the comp case while it was disallowed.
Or like they lose the appeal on fraud and they're not still settling, right? Or they're not really worried because they're just using the medical status to prop up something on the civil claim.
Yes, it happens.
Yeah, it happens all the time.
Yep.
I think that what we're going through is really going to be determined by, the truth tellers that are penning this letter to Dr. Lerman, right? Like whether or not the attorneys can prove a cognizable injury in Roosevelt Road and Tradesman. Like all of these things have so many developments that we're not going to know for years, but like it is very, very interesting to be at ground level where this is really starting to take place.
Can I ask each of you a
No.
question? If you had to change one thing in the New York workers' compensation law, one thing, a law, procedure, what would it be and why? I could go first if you want.
Well, I think if you started, maybe you should go first. I do want to think about this.
Think about it while I tell you. I would change Section 13 of the workers' compensation law. The claimant having control of medical treatment is what causes the wagon to go off its wheels. It's what causes the train to be runaway. If you look at similarly situated neighboring states such as New Jersey, I mean, the Garden State fares much better than New York in terms of its premiums, in terms of its claims, and it has a similar population that, of course, it's less in terms of construction, but it would be easier for a plaintiff, a claimant, to file as a petitioner in New Jersey, right? When you look at these patterns, the main difference between New York and New Jersey is that in New Jersey, the carrier maintains medical control. The employer selects the treating physician, the employer selects the independent medical examiner, and you don't have this chicanery. You don't have these Lerman letters. You don't have these par requests because the claimant chose, quote unquote, the doctor. If I could change one thing, and look, there's a million other things I hate in the workers' comp system, right? I hate that unwitnessed accidents are presumed compensable. I think that's ridiculous. Just because you didn't see it doesn't mean it happened. Well, actually, in workers' comp, it means it did happen. No, but I think Section 13 should be redone. I think employers and carriers need to select the treating physicians, and the number of claims will go down, but so will the amount of fraud.
It's interesting, the fraud element, right? So in workers' compensation, you litigate fraud and there's a fraud finding. What does that mean? That means that the claimant may have his benefits, meaning his awards, monetary awards, suspended. But sometimes the fraud is so egregious, I feel like they should also say that the claimant cannot get medical treatment as well. Because we've gotten, surveillance of the claimant, exaggerating or not exaggerating or whatever it is. The fraud is so bad, right, that once the judge finds that, yes, I find that there is fraud here, I think there should be some change in the law where even the medical portion of that, the claimant should not be able to get covered.
Yeah, it's permissible, additive to the discretionary penalty. You failed to disclose this prior ACL tear, you can't get knee treatment under the comp claim.
Correct.
Right?
Why should the carrier
you're not
pay
paying
for
it? Right. It's unrelated.
Right. That's a good one. That's a good one. I probably actually, now that you say that, would probably pick that one because I think fraud is so rampant.
Mm-hmm.
And, we just talked about how you can find fraud, but then the claimant doesn't care because they're using the medical to just beef up their civil claim.
And can I just say now, keep in mind, so we have the litigation funding, right? So this really hurts us, by the way. I don't know if everyone's aware of the litigation funding. So these guys, although we're fighting to get their benefits, weekly benefits suspended,
they have money.
They don't care. They've gotten a litigation loan. They're able to get money in that way. So even though we've gotten that suspended, they can treat, right? And now the carrier is still responsible for causally related treatment, and they're getting the litigation funding. So it's really, I think if we were able to say, well, even treatment under that fraud statute will then be taken away, then that would change the game.
Yeah, I mean, to both those points, I think there is a laundry list of things. I think the thing that popped into my head was 25-2B. You're going to lose 3 important defenses because of a piece of paper. In 25 days, you're requesting a complete investigation, and in your garden variety case, 25 days can be enough, right? What if someone files a claim and they allege an accident a year ago, right? How's that fair, right? So the idea that you are the board and you're sending a piece of paper to potentially an excess carrier and not the third party administrator who's responsible for denying the claim, and to lose defenses like that outright is preposterous to me.
Or to the alleged employer.
Because
then they'd say, "Who is this guy?"
Right.
Yeah,
you're right.
That's actually a whole nother podcast, right? It's just we could just have anybody. I mean, there's pick one thing that you would change, right?
But it's funny. The heart of our answers all have to do with getting to the Truth.
Yep.
It doesn't have to do with making our lives easier or making claimants, suffer more. It's getting to the truth of what is being asserted. That's what I was getting at. I made a wager that all of us would have the same spirit in what we would want to change. And, there it is. There it is.
I think we have to end there, right? We have to end there. And thank you guys for coming to the makeshift location of the Third Fridays podcast in my office today. So again, let's all give our grateful thanks to our producer, who is going to deal with the background noise surrounding us, and putting forth a good episode this month for all the listeners out there. But for Meisha Powell and Addison O'Donnell, my name is Christian Cisan, reminding you to defend from day one.